Data is undoubtedly the new oil, and protecting the generators of this data, that is all of us, has become one of the biggest challenges for governments across the world. In India, for example, we currently don't have a framework that protects our data. Now, the Personal Data Protection Bill 2019 is supposed to do that. But one of the key architects of the original report that the bill is based on is deeply concerned. Justice Srikrishna, in an interview to the Economic Times, has said that the tweaks in the final bill that allow government agencies to override any safeguards is dangerous and can turn India into an Orwellian state. Now remember, this piece of legislation is a crucial one because it determines who has access to your information that you generate on your phone, on social media, or whenever you click online. So why the great concern from Justice Srikrishna? To understand more on this landmark bill, I'm joined today by Apar Gupta, Supreme Court lawyer, and of course he heads IFF, the India Freedom Foundation, Akriti Gaur, senior resident fellow at Vidhi Center, and Neha Chaudhary, Director of Public Policy at Ikigai Law. Welcome to all of you and thank you for speaking with us today. Apar, let me begin with you. And as always, I know all of you are experts, but please, all of our viewers must understand what's going on. It's absolutely crucial. So I request you to keep the jargon to a minimum. Why is Justice Srikrishna so upset and should we be worried?
Justice Sri Krishna has voiced a very valid concern, and this becomes very apparent from looking at clause 35 of the draft bill which has been proposed by the government as it has been introduced in the Lok Sabha. This draft bill by itself is not up for passage right now, which means that it is being introduced but it is not being voted into onto in its current form, but has been referred to a select committee of parliament which will further deliberate upon it. So just in terms of a process, I would like to break it down for our viewers that there is still scope for change within it, and the language within it can in fact become even better in terms of removing these kind of fears of the government having a greater control over the power, over the personal data of individual citizens. And there are two concerns which I would like to highlight. One is with respect to clause 35, which is the power of exemption given to central government offices just through the passage of an order in which they can be exempt from the application of the provisions of the Act, which means that the Act will just not apply to them. And as we know today, the government is one of the greatest gatherers of data, and as per the National Economic Survey in Chapter 4, is looking at people like you and me, not only as people who will pay their taxes, but also pay the government in its personal data, which they can then sell through databases such as the Vahan database. The second issue is that the Data Protection Authority, which is the regulatory body set up under the Act for administering this law, will be selected by a selection committee which is principally headed by all members of the government. It does not have any diversity, it does not have any person from let's say the opposition party or even a member of the judiciary, and this goes against the draft language which was suggested by Justice Sri Krishna. So there are two significant departures here. With firstly with regard to the substantive exemption which is available to government departments by virtue of an order, you're completely exempt, and the second is with respect to the Data Protection Authority which has the danger of turning into a completely sarkari body.
Okay, so now if I understand this, Akriti, let me come to you. That means that the government has given itself a blank check to access any data if it so deems fit. But there are a lot of conditions for private players also, your intermediaries, your social media intermediaries, your data fiduciaries, that means the companies that generate data, and they are worried as well. We've had a statement from Nisha Biswal of the US IBC saying that, there's some of this which is worrying them. What is their concern?
Right. So I think we need to speak about the term that has been introduced in this bill. It's called social media intermediaries. Now, the idea is that any social media company which goes, and this is what the bill says, above a particular threshold of users can be notified by the government as a significant data fiduciary. If you go a little provisions down, you see that now this new class of social media intermediaries has an obligation to voluntarily verify its users. Now, I have a lot of issues with the formulation here, because first of all, the definition of social media intermediaries in the bill right now is not very clear. They've not defined what a user means. It simply says, any platform which solely facilitates online interaction between two or more people, etc. So this definition is definitely going to put a lot of, be it social media platforms or others, hybrid platforms as you may call them, in a lot of certainty. Now the second obligation, which to me is very peculiar, because an intermediary accountability provision, I'm failing to understand why it's there in a data protection law, because verifying users, knowing who's using Twitter or Facebook is perhaps not directly connected to the privacy question or the data protection question that this bill seeks to resolve. So as you see, this is also going to overlap with the Information Technology Act, the intermediaries guidelines which are under that. So it's going to create some significant confusion for these players for sure.
Okay, as I understand it, Neha Chaudhary, the basic premise of the bill is to protect our data from anyone who has access to it. Now, whether it is social media intermediaries like Facebook, WhatsApp, etc., or whether it's large players, Amazon, Flipkart, etc. Now, at least does it do a good job in protecting my data that these guys have?
To a large extent, this is a huge and significant improvement over the current framework that we have under current Indian law, which is under the Information Technology Act. Under the IT Act, the only safeguards that are available to you and I are for our sensitive personal information, the bulk of them. So yes, to a very large extent, this bill does grant the data principle, which is you and I, the individual, a lot of rights over our information. It puts us in control of our information, because we are now entitled to notice information can only be processed on the basis of our consent. There's a whole host of rights that we now have as data principles, including the right to erasure, the right to deletion, the right to data portability. There's a whole bunch of them. So to a very large extent, it does do, it's a significant improvement over the current Indian framework that we have. That said, there are a whole host of concerns, right? So, and I think that's really the dichotomy that we're struggling with here, that my information is private, or I'm in control of my information to a very large extent vis-a-vis companies. But when it comes to how this bill applies to the government, I agree with everything that Apar was talking about.
Okay.
Yeah.
So now let me break it down from what we've understood so far. And remember, we're talking about data protection in a country which now is generating huge amounts of data, where a bulk of the viewers, of the users, I might go as far as to saying 99% of those who are generating data have no concept of privacy of their data. They have no idea. So, with examples, can you explain to me, Apar, why it's dangerous for the government to have overriding powers, and don't they need it? Don't they need it? They're saying that if it's reasonable, if I need it for security purposes, if I need to know if an illegal act is committed, etc., then I want to dip in and find out who has generated that data. On the face of it, there seems like there could be an argument for that.
So, well, certainly, the argument for surveillance reform has always been that the government can surveil, but it needs to be done with a degree of oversight, and it needs to be done proportionally to the intended purpose of serving a legitimate state goal, which is quite often to prevent law and order breaches or to serve security interests. Now, the problem which arises here is, firstly, the law by itself does not deal with surveillance reform. Surveillance is essentially when your data is gathered non-consensually through frameworks in which there is surveillance happening, such as telephone tapping, through CCTVs or through facial recognition. And this is done under enactments which are there under the Telegraph Act, and this law, to my reading, would not apply very directly onto that. There are no clean amendments which are being made to the telegraph law. So the powers of surveillance of the government are already there. They are already established. They are already under challenge, in fact, but they are not being tinkered with. What this law is actually doing, it's permitting the government, when data is shared consensually, which is with consent, and when data protection principles apply, that this data should not be shared with a third party without your consent. The government is seeking to exempt not the requisition in certain instances of that data of you and me. So Tamanna's data or Apar's data, when it is requisitioned by, let's say, a government agency, is not within the purview of the exemption here. The exemption goes much further and beyond. It exempts a complete government department from requisitioning it. So it's not case by case basis. It's not individual instances. It's not when a specific situation arises and it asks for a certain type of data. The exemption here is a blanket exemption to a government department which is through a government order. Okay. And this by itself is problematic because it means that provisions of the Act become completely inapplicable to that government or government agency.
Okay, so as I mentioned earlier, should we look at this as a blank check the government has given itself to access any of your data, and why that is concerning? Akriti, if you can come in on just that aspect, because some very strong words coming in from Justice Srikrishna over here. What can be changed? What can be changed to make experts like you more comfortable with what the law is proposing right now? And remember, we are currently, if you look at the ideal and where we are really in this law, somewhere in the middle, we're currently in a situation where there's a free-for-all as far as our data is concerned. If you're talking about a product, it's likely that the moment you type into your computer, you'll see an ad on something related to it. So that's the reality of where we are. So from that context, what would you like to see changed or included?
Yeah. No, absolutely. I take that point, Tamanna, and I absolutely agree with Apar. You know, when he talks about how the government has given itself like a blank check to, carry out a surveillance activity for any purpose, and I think we should also, as in to discuss the context in which these protections are necessary, would be to go back to the Supreme Court's judgment in Puttaswamy, where the necessity and proportionality tests were laid down, where there's been a stringent measure for which such activity should be taking place, if at all. And I think this draft completely has missed that point, or any development which was happening on that front, because this provision, as was also mentioned earlier, should have ideally provided for a judicial oversight, specific purpose for which, if any activity such as, a surveillance activity needs to happen. And I also feel like we need to go back and even see whether an exemption for national security activities should or should not be there in a data protection law. Do we, leave it out, etc. So I think there are lots of foundational questions which need to be examined, which have been completely bypassed in this, in this bill, and there is a need to ensure that any provision of this nature is in conformity with the judgment which was made in Puttaswamy, because otherwise anyone at any point, would be a target of surveillance. You may not get to know. It could be multiple departments of the center or the state, any agency, and this is deeply problematic.
Okay, maybe not the most intelligent question, but honest one. Isn't that happening already? Doesn't the government already have the means and ways of looking at anyone's data if they so see fit? Because again, sometimes I feel the whole conversation about data privacy is sometimes in a very ideal situation, and you have to look at what reality we're living in when you talk about it. Akriti, I'll let you take that.
Yeah, no, absolutely agree with you. And I'm not saying that, this bill has created a new provision which is going to, negate something or bring something to life. It's already happening. But, this was an opportunity, and I'd be optimistic. This is an opportunity to ensure that, if we have the first comprehensive data protection law for India, that it takes care of some of these things and not just exacerbates them and give the government more responsibility. And as I think a lot of us here would know, that there are surveillance activities being carried out day in, day out. There are a few laws which take care of that, and you have the wiretapping laws, etc. But we know they don't work. So this is an opportunity for a data protection law to deal with activities which are going on, and to figure out a way to not give them a blanket exemption.
Yeah. Neha, let me just get a sense from you on how this deals with private companies gathering our data. And we've just been talking about the big giants, the MNCs, the global companies, your Walmart, Amazon, and of course Flipkart, etc. What about the startups? Now we are in a age and stage where there's a startup boom, and it all depends on data. Now there's some concerns which have been expressed, saying that very tight privacy laws might be a death knell to the whole startup buzz in India.
Yeah, sure, absolutely. Why don't I share with you some feedback that we've been getting from some of our clients we work with a range of startups across a whole range of different sectors. Couple of concerns, right? One is this idea of purpose limitation, where you have to specify upfront what the purpose of what the purpose is of collecting that information. Essentially, if I collect 5 data points from you, what exactly I'm going to do with them. A lot of companies in the emerging tech space that want to play around with big, that want to play around with the data, do a little bit of data analytics, so on and so forth, are a little bit worried and saying, well, what if it's not possible for me to identify the purpose for you upfront? What happens then? So that's one sort of concern that we've heard. The second concern, and to a certain extent this has been dealt with in the bill, has been related to the cross-border flow of information, right? So the free flow of information across borders. In the earlier draft, in the 2018 version of Justice Srikrishna Committee, there was a requirement to store a copy of all personal information in India. Now that language has been deleted from the 2019 draft, but what you do have is a very wide category of sensitive personal data and information that includes everything from financial information to biometrics to a whole bunch of other things. And the central government has the power to notify additional categories of information to be sensitive. Now, this information must be processed in India, must be stored in India, but you can take it outside for processing. So there's a little bit of concern there over exactly what I'm allowed to do with information that falls under a fairly wide bucket of sensitive personal data and information. The third concern, and this is a little bit out of the blue again, is this business of non-personal data now being introduced into a personal data protection bill. Now, the government has the power to ask any company to provide anonymized personal data or non-personal data, which is everything except personal data, with the government for providing certain services or to help it in decision-making processes. And businesses are concerned because this has a lot of implications for business information, for confidential information, for intellectual property rights. And in any case, we have now, there's a committee that's looking into the issue of non-personal data that's yet to come out with a white paper. They're in the process of consultations as far as we imagine. So a lot of sort of concern there as well as to why are we talking about non-personal data in a personal data protection bill?
Okay.
And this business of mandatory sharing of information with the government.
Well, so net at the end of it, the question is about how much of our data the government can access without having to answer to a judge somewhere about why they need it. This is still not in the stages of being finalized. It's gone to a joint committee. So let's wait and see how much push and pull before the final version is passed into law. Remember, this might not be the hottest headline you see everywhere, but it's the one which actually affects each and every one of us. So keep an eye on it. And I want to thank all of you for joining us on this deep dive this evening.